The Supreme Court verdict in Antrix-Devas case raises a question about whether the international award can itself be sustained in the context of established fraud in India. This case raises the same questions that came up in the 2G spectrum and coal block allocation scams. In both cases, the Supreme Court held that the allocations were in contravention of rules and arbitrary in nature, and thus all licenses could be cancelled. The larger question, who is liable for how much of the fraud remains while the primary perpetrators of the scam can be prosecuted? What happens if investors who came in later were unaware of the fraud and invested in the company in good faith? In the 2G scam, international investors including Norway's Telenor burnt their fingers by investing in the domestic telecom companies that won spectrum and licenses using dubious means. It is interesting that none of the international parties affected by a domestic scam has obtained any kind of international compensation under any investment treaty. Clearly, they accept that indirect victims of fraud cannot expect to benefit if the primary fraud is proved in court. Now that Antrix, ISRO and the government have won the battle at home, they would do well to assure indirect victims of the judgment, who may not have been party to the fraud or misrepresentation, that this does not mean their future investments will be at a similar risk. On the other hand, the government and Antrix cannot assume that the shareholders of Devas will not continue to sue abroad. They need to continue the fight even while reassuring investors that their money is safe as long as they understand who they are getting into bed with. The lesson for international investors is actually basic. Do your due diligence before putting your money into Indian joint ventures.